My name is Maria Weiner, and I'm the president of Florida Caregivers Network. So I am so ready to start this day. I've been ready for the past 7 months.
So have we.
Yes, ma'am. Good morning, everyone, and welcome to the second annual Caregiver Conference, Getting Real About Reality. Today will be a special day for all the caregivers in this room and professionals that care or know someone that lives with dementia. I hope that by the end of this day, you guys are re-energized with all this information we're going to give you, have the tools, have all the resources for you to take care of your loved one. So we're going to start and we're going to get real about reality. I want to welcome our next speaker, Mr. Brooks Gentry. He's a local elder law attorney specializing in estate, Medicaid, and Alzheimer's planning. He obtained his law degree with honors, then graduated with distinction with his legal master's degree in elder law from Stetson College of Law. For the last several years, Brooks has navigated the very challenging journey as caregiver for his mother, who was diagnosed with Alzheimer's in 2008. He is a passionate legal and political advocate for those with dementia, their families, and other caregivers, and facilitates a younger caregiver support group on behalf of the Alzheimer's Association. Professionally, Brooks is a member of the Florida Bar's Elder Law section and serves monthly on the Florida Bar Medicaid Committee. He's also a member of the National Academy of Elder Law Attorneys, serves as the secretary of the prestigious Penick Elder Law Inn of Court, and contributes locally for ABC Action News. As an understanding caregiver, both personally and professionally, Brooks brings compassionate counsel to all those he serves. Please welcome Brooks Gentry.
Hello, my name is Brooks Gentry. I did not bring materials today, so if you have a pen and paper, take a second. You are welcome to write down my email address, and I'm going to blast through my part and give you a lot of information. So if you have questions after today, feel free just to email me directly. I'm not one of those foofy attorneys that's not approachable. I am at your service and happy to help in any way I can. So my first name is Brooks, B-R-O-O-K-S, at, the little at symbol. Last name Gentry, G-E-N-T-R-Y, Elder, E-L-D-E-R, Law, L-A-W.com, Brooks at GentryElderLaw.com. So, I'm a caregiver, as you heard. My mom, I've been on this caregiving journey for about 10 years. My mom was diagnosed in 2008. I moved in with her for 9 months after the diagnosis. It was probably the worst 9 months of my life, or at least the worst 6 months before I figured out all that I was doing wrong, which really gets me to something that relates to what you heard just before I came on. A lot of those solutions that you are learning, thank you for being here to learn them, are really counterintuitive. So I want, if you're a caregiver who has ever been stressed out by your caregiving, to please raise your hand. Okay, number one, you're stressed because you care. Congratulations, that's a good thing. The thing that took me the longest to learn is that everything I thought I should do on my mom's behalf, out of respect for a strong, independent, intelligent woman, turned out to be the worst thing you can do, because intuitively I thought, let's involve mom and involve mom, right? Wrong. So the counterintuitive thing that turned out to actually work was not involve mom, do things that you need to do on your client or loved one's behalf, just get them done. They don't necessarily need to be part of that process. As a caregiver who is stressed, because you care, Something that I learned recently is a practice you may have heard of, living in the moment, that kind of Zen thing. I suppose this ties into that, but it really is going to start with you accepting the fact that you're human. Like everything else you've learned, it's going to take trial and error. So the key to yourself, caring for yourself, is to have self-compassion. We're compassionate towards others, you're compassionate towards the person you're caring for. I want you to be compassionate on yourself. That will free you up tremendously of any guilt that you have for any mistakes that you've made. Every day is a fresh start. Keep learning, keep doing what you're doing, correct what you can. I promise you'll get better at it. So, when you get a diagnosis, or even before then, you start noticing something is going on, you need to assemble your team. And your team is going to require no less than a medical team that includes a primary and definitely a neurologist, and I stress a neurologist that understands and practices dementia-related neurology. An oncology neurologist is not qualified to diagnose Alzheimer's. And I'm going to, at this moment, start talking a little bit firmly about the medical community and the legal community. And I mean no ill will, but I see it time and time again that sometimes getting in the hands of the wrong professional does a whole lot more harm than good. So you need to do your due diligence and be extremely careful that you are getting your loved one in the hands of somebody who understands dementia and Alzheimer's. Primary doctors, unfortunately, are often the worst offenders. So if you've taken your loved one to a primary, or they've gone to their own primary and the primary dismisses any kind of memory issues, go to somebody else. And I was just talking about this. I see it a lot. The person who has the medical condition ends up being told by a primary, or maybe the wrong type of neurologist, you don't have a problem. And all that does is feed their denial. Now you're coping as a caregiver with their stronger denial. Meanwhile, they need that much more help. So a solution to that can be quite simple. There are 2 memory clinics in Pinellas County that are the big memory clinics. There's one in St. Anthony's and St. Pete, so if you're South County, you can start there. Morton Plant, Celeste Bonner's already talked about their memory clinic. You can start there if you're in North County. What I find is that the family can sometimes be so discombobulated because they're getting bad information that they can't get their loved one in the hands of any type of doctor anymore because they're just too intimidated by it all. If you go to a memory clinic, they are designed specifically to be less intimidating, to be a much softer intake process. Sometimes they just start with a very simple memory screening. It's not the very scary, PET scans and all these other big diagnostic tools that a proper neurologist would use. That memory clinic is also tied directly to neurologists who specialize in dementia. That's a great way to get your hands into the right doctor's office from the start. If you end up there, you can sometimes go back. You can ask for a referral to a primary. If you've got insurance concerns, work through your insurance to find people that are in your network, but that's a good way to get into the right hands. But your team also needs to consist of people who understand dementia, and they understand that sometimes the information they're getting from their own client is inaccurate. And they need to understand that you represent accuracy. Your client, their client may not. An accountant, bankers, financial advisors, you need them, and I'll explain why. But you also need those who understand dementia so that they don't keep turning to your client or loved one asking for information and then processing their work off of bad information. Lawyers are the same way. There went the bus, right over their heads. So here's the reason I say that. Just yesterday, I sat at an 86-year-old man's kitchen table, which I do often, and his son was at the end of the table. Son is a caregiver, very stressed out. And the man's wife is in rehab, and she's soon going to be transferred into a facility. She's got cognitive issues, we think dementia-related, and so forth. 13, 14 months ago, the son took them to an attorney in Tampa. And that attorney proceeded knowing full well that mom had cognitive issues at that time, to do document work. Now, I'm going to blast through some legal information. In 2011, the Florida statute that controls power of attorney documents was changed, and it was flipped upside down. Before 2011, you could have a short, sweet, one-sentence power of attorney that said, I give so-and-so the power to do anything, period, and they could go do it. And they did, and they abused the heck out of it. So the legislature figured out that, well, if they're abusing the fact that they have powers that are so broad, nobody can figure out what they really are, then let's make them say it explicitly. So the new law says, if you expect a power to be given to your agent under a power of attorney, that exact power has to be enumerated in the document. So we went from 1 page, maybe 3 or 4 page documents, to now almost 20 page. Every single power you could possibly need needs to be written in the document. My documents have over 90 powers in them. On top of that, 4 powers the legislature deemed were being so heavily abused and are so important that they were now called, or are now called, superpowers. Ironically, the superpowers are also the most important powers to you as a caregiver. It's the powers to make gifts, which has nothing to do with something put into a box with wrapping paper and a pretty bow on top. A gift is any time you transfer pretty much anything. In our world, it's most always money. Any movement of money from one person's name to another is a gift. If you haven't gotten into it yet, if you're dealing with dementia and Alzheimer's and a facility is on the horizon, at some point you'll talk about Medicaid planning. You can't do Medicaid planning without the power to gift. A large part of Medicaid planning involves moving money. If that document does not have, number one, the superpower of making gifts, which most of the old ones do, you can't do it. On top of that, if it's not initialed, you can't do it. And the key to the law in 2011, the change, is that it was applied what we call retroactively, which means it actually applies to all of the old documents prior to 2011. They are not just grandfathered in and accepted as they are. So 86-year-old dad sitting at the table yesterday hands me the documents that this attorney did 13 months ago, 4 years after the law changed. There are no superpowers in the document. It's 5 pages. It has no mention of applying for public benefits. It's completely insufficient. And the mom has dementia, and I can't work with her. Done. I can't tell you how upset this makes me. What people don't realize when you go to an attorney who doesn't know how to practice elder law, and by the way, elder law really means that we have been trained not only in regular estate planning, which of course I do for anybody of any age, but elder law specifically takes it to the advanced level of dealing with people as they age, and all of the different dynamics that come into play specifically as you age, and they are complicated. An elder law attorney is a very specialized attorney. We have to try and keep up with the Medicaid law, which in and of itself is mind-blowing, Social Security, all kinds of retirement things, your IRAs, your annuities, your life insurances. We try to keep up with all of it. If you go sit with a regular estate planning attorney and they don't know anything about Medicaid and they're doing work for your parents, that's not the right attorney to be with. So, what can this family do? Really, unfortunately, not a whole lot. And what that really means is this: if they had a valid power of attorney that would allow me to work with the son on the mother's behalf, we could move dad's assets around several hundreds of thousands of dollars and not only hopefully get them VA benefits, which is something else that we deal with, but also the Medicaid benefits that would help, of course, contribute to her care while she's in a facility. But as part of that Medicaid planning, we do wealth preservation and asset sheltering, essentially. And we move that money out of the parent's name so that they are eligible, but we preserve it by putting in the hands, usually of a child, not always, but into somebody else's hands so the money can stay for the long haul. Because as most of you all know, this is not a fast disease progression. Some people with Alzheimer's or other types of dementia can last for literally decades. And it costs tens of thousands of dollars a year. It only takes 5-6 years to blow through a few $100,000. And what this attorney has just cost this family is not $1,100 that they may miss out on from Medicaid. It has cost this family hundreds of thousands of dollars that I cannot preserve because the power of attorney document that was done 4 years after the statute changed was not done by an attorney who understood what the law requires. So, that said, your team you want to assemble before you get a diagnosis if possible, but I do not want you to think that that's required. As an elder law attorney, one of the things that we're trained about is how our ethics rules require that we treat clients who have what is called diminished capacity just like any other client. On top of that, if we're going to make any accommodations for them, the accommodation that we need to make is to try and maximize their capacity, to find lucid intervals, whatever it takes to find them, and try to help them through legal work. The law and the Florida bar know that these people are vulnerable and needy and they need the protection of the law. So a good elder law attorney is going to work, if possible, as hard as we can to get done the legal work that your loved one needs. If you've got a full-blown diagnosis and sometimes you'll end up, you go through the diagnostics and the neurologist will write a letter of competency. And a good neurologist will ask, why do you need this? Because they understand the consequence. The consequence can be you end up with a letter of incapacity and you're trying to simply show to somebody that they can't make their own decisions, therefore you need to be able to exercise your powers and the power of attorney to get something done. Fine. But if you end up trying to do Medicaid planning and then you end up with an issue down the road, what's going to be challenged is you're using a document that the client, the patient, your loved one, the person you're caregiving for, may have signed, or what we call executed, after a diagnosis and after there's a letter of incompetency. So there's a bit of a conflict there. But the reality is, some of us will take that risk, and it's a risk that's on the attorney, because at the end of the day, the attorney sitting across from their client is in that moment the arbitrator of whether or not that person understands what they need to understand before they sign the document. It's not a doctor, it's not you, it's us. And a good elder law attorney is going to understand that. And when I say maximize capacity, that incorporates a host of technique. And it's a skill set that is honed and takes time to get good at. You have to talk simply, but you have to be pretty point blank. You can't ask somebody to sign a document without them having some understanding of what it does. And one of the biggest risks of these documents, particularly the power of attorney, is yes, your son can go down to the bank and close your bank account and take every dollar that's in it and go to Vegas and gamble it away. And unfortunately, the reality is there's no recourse for that. What's gone is gone. Sure, we could litigate, we can try and get a judgment, but he's judgment proof because he has no money to pay mom and dad back. Going to the neurologist or whoever and getting your diagnostic workup, ideally, like I said, you would come to an elder law attorney's office and do the legal work ahead of time before doing that, but it is not precluded from being done, or it's not impossible to do after you've done the workup. I will say this, if you can, get it done as soon as possible after the diagnosis, because your world's about to change, and frankly, you're not going to have all the wherewithal in a short matter of time to get everything done that you need to get done right after the diagnosis. Let's see. I don't know, I'm not a doctor. I don't even pretend to be a doctor, but I've been around this long enough to know a few things. You all may have heard already today, you can't diagnose Alzheimer's. Alzheimer's itself is actually diagnosed through deduction. The only way to diagnose Alzheimer's is upon autopsy, after taking out the deceased person's brain and looking at it. If you have a primary doctor who turns to your loved one and says, you don't have Alzheimer's, you need another doctor. Because did they do anything to show that the person doesn't have Alzheimer's? The neurologist who specialize in it will do not just what we call a little mini memory test, MMSE is the acronym. They do a full battery of testing. It's psychoanalytical something or other, where your loved one basically has to go through 3 to 6 hours of a battery of psychological evaluating questions and answers and that kind of testing. On top of that, you'll hear doctors who will, I'll do an EEG, or I'll do a light scan. None of that is sufficient. If you're really going for a full-blown Alzheimer's diagnosis, a PET scan is the best thing we've got. It's the only thing we've got. MRIs, not sufficient. CT scans, not truly sufficient. Spinal taps, not truly sufficient. You get in the right hands of the right neurologist, and you'll see how there is a protocol that they follow, and it's the best protocol we've got. It's not perfect and it's not conclusive, but that's the point. If anybody tries to tell you conclusively that they've concluded something without doing that battery of testing, you need to question that. Okay. Back to the story. So, what can we do? If somebody has unfortunately done legal work that's not sufficient and then has gotten to the point where we can't do the work for them, we're really in backpedal mode, because now the only person that I really can work with in this family is the father, who's 86 years old and stressed out. And it really, this is such a weird thing to say, but it really is true. I've literally had to say to him, you now need to stay alive. You need to stay healthy. You're the spouse, your son, and by the way, when you're the child or when you're a caregiver who's not the spouse, if you've ever tried to work, trying to work with the VA on a good day is tough. But if you don't have power of attorney, forget about it. Same thing with Social Security, same thing these days with all the identity theft going on, dealing with financial institutions. But if you're the spouse, you may get a little bit further than some. So I said to the dad, your number one priority right now, you need to go be vegan and, eat fish oil and stuff like that, because you really need to survive at least long enough for us to get these things in place as best we can. And he just kind of looked at me. But that's the truth. That's how important these documents are. And then the son is sitting there with his hands tied, because he's the one who's been doing everything for his dad, because he is trying to help his dad. So you can see how it all just compounds. So getting good quality legal documents is very important. Assembling your team is very important, and communication between your team is very important. We all know about HIPAA. HIPAA these days is getting even more locked down because of the identity theft. You might have just seen recently a hospital actually had to go back to trying to operate on paper. That cracked me up. I don't see how they got through the day, because they had a computer malware problem. HIPAA is a roadblock that is based on the human being in front of you in that moment, exercising their judgment whether or not to try and work with you. What we do as elder law attorneys is we put together a package of documents that, as a total, gives the risk management department, which is like the little legal department in all the hospitals, everything that we can throw at them to do what we need to do. And all we need to do is simple. We need them to feel like they're not liable, that they're not going to get sued. Doctors don't want to get sued. Nurses in hospitals and all of the medical community does not want to get sued. That's why they're telling you they can't talk to you. So, documents such as the healthcare surrogate, in conjunction with the document we all know from Terry Schiavo, the living will, and nowadays in conjunction with a fairly new document called a HIPAA authorization and release form, all work together to give that medical person in front of you enough confidence that your loved one has done everything they can do to satisfy the HIPAA requirements. A HIPAA authorization form, at least the one that I do, doesn't even mention the name of the person. It references specifically the surrogate from the healthcare surrogate and the agent if we put medical powers into the power of attorney. So it's actually pointing over to another document. And I'll give you a little tip here. So we can do a power of attorney that has medical powers in it. That needs to be consistent with the healthcare surrogate. So in other words, if we've got Jane Doe over here as agent under power of attorney and John Doe over here with healthcare surrogate, I'm not going to put medical powers in the power of attorney. Healthcare surrogate's going to give John what he needs to do medical, and we'll keep the business stuff being taken care of by Jane. But if it's the same person, we're comfortable putting in medical powers and the power of attorney. Healthcare surrogate says the same name. There's a living will, and then on top of that, we do a HIPAA authorization form pointing to the other two documents. You take those 4 documents and you give them to any risk manager, and all they're going to say is, thank you, we'll talk to you all day long. It's pretty much the way it is. Now, that said, the caveat is you've got to remember you're dealing with a human being on the other side. And they don't always understand it, and they don't always do what we want them to do. And a little tidbit too, in the emergency room, entirely different setting. You have to know when somebody's being admitted into the ER, the role of the ER is to stabilize the person, not to treat them per se. They don't necessarily need a whole medical history in order to stabilize a person. So it is common that when your loved one goes into an ER, if you're particularly a child who's out of the area or a caregiver who's not able to go down there in person, they may not be willing at that moment to talk to you. They're really, frankly, just too busy trying to save your loved one's life. That's okay. Don't get angry with them. The worst thing you can do is show up in an ER and start picking fights, because all they're going to want to do is kick you out. But be nice, be congenial, cooperative. I may have information that can help. I can tell you probably the most information you can bring them is a medications list, which as a caregiver, by the way, you want to make sure that the medication list is always accurate. If your loved one's in a facility, always get the medication list that they're required to keep so that you can show your doctors exactly what medications the person is truly being prescribed. Make sure that all the doctors involved, your team of doctors, are all communicating with each other. They do not automatically communicate with each other. We even think that sometimes in this big world of big conglomerate systems, Morton Plant, Baycare, that they all talk amongst themselves in the same network because they're in the same network. It does not work that way. So as a caregiver, you go to the doctor's office with the meds list, and after the appointment, you always say, make sure this gets sent back to the primary, that kind of thing. You're responsible, really, because your loved one can't do it, for making sure that all the information gets where it needs to go. And then something else, just kind of an insider thing about lawyers. We all care. We wouldn't take on this responsibility if we didn't care. But I'm quickly learning, these days with modern technology, there's 2 types of lawyers. There are the type that embrace technology and the type that don't. Okay, I get that. I don't embrace all technology. But one thing that technology provides us as lawyers is software. And one thing that software requires is updating. Some lawyers are not software users, and that's fine. They have libraries of documents, drafts, templates, whatever you want to call them, that they've been using for a very long time. I'm not one of those attorneys. I use software. It does not necessarily mean that it takes me less time to do the documents. I use software because the software that I use is created and supervised by a national law firm that, if I mention the name, every one of you would recognize. They have an entire division dedicated to nothing but legislative updates. And then on top of that, the software has multiple committees with multiple people on the committees who review those updates and apply them to the individual states. Because all of this type of law is controlled by state law. Medicaid is federal and state, but for these documents and estate planning, it's all state. Every year, my software gets updated with the current law. And the documents are fixed to accommodate the current law. For example, just last year, the healthcare surrogate law changed. Now, a healthcare surrogate, in order to be effective, has to have an effective date. You can imagine a doctor getting this healthcare surrogate years gone by with no date saying, when is this really supposed to take effect? And the family member sitting there going, it should take effect now. They can't speak on their own behalf. And the doctor says, well, but I'm not quite sure on that. Simple solution. Say it's effective immediately. Done. The minute your loved one signs the document, it can work. Software fixed that problem. If you use software, you know that the document that you just downloaded for the next year contains those 3 words. It's effective immediately. The reason I stress that is you can tell when an attorney's used software because they are nice, tidy, robust, thorough documents. The document that the 86-year-old handed me yesterday is not from software. And the law changed over 5 years ago. There's not much excuse for that. So go to the right attorneys, get to the right doctors, give yourself a lot of self-compassion, and thank you for being here.